Okay, we are back in Senate institutions on March 10th, 2026. And now we are getting a review and a discussion of S-193. And that is a bill that is proposing to establish a forensic facility. And this committee's jurisdiction, just to be clear, is the buildings of the state, and those include correctional buildings. And so whether or not that is a good fit in corrections is that's the main reason that we've asked for information. And today doesn't need to be the last day that we take testimony. We can take testimony later on if there are unanswered questions that the committee has. I think we have a great group of folks, and I really appreciate you all being able to be here on relatively short notice. So we have copies of the bill if anybody would like one.
I have. I got it online.
Okay. Well, it's not, it's been revised. So it's, the draft I have is 4.1, which I think is, I'm sorry.
And so we heard this morning in the health department.
Oh, okay, perfect.
Making sure I haven't revised it since then. Yeah, true. It's not.
Yeah, then you will be our expert. Okay, so we have Karen Barber, General Counsel, Department. Oh, I'm sorry, Eric Fitzpatrick. He's going to
Yeah, sure.
test or
Sounds good.
take us through the bill. Thank you.
All right, good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair said, here to give the committee a walkthrough of Senate Bill number 93, which is activating to establishing a forensic facility for certain criminal justice involved persons. I'm not sure if I should just kind of go through the bill. I'll give you a minute or two of background first, but
Yes.
you were mentioning sort of your area of concern, so I could focus on certain parts or whatever you think might be helpful. But
If we
Well,
can go through the
yeah,
the background and
yeah,
that'd be great.
Yeah, and I think I should have also said that the competency restoration services, that to me is a no-brainer. That should be happening. And so that is definitely a benefit to the state. And I'm not I don't have concerns about that. But obviously we're a committee of 5, so I can't speak for everyone. But yeah, why don't you give us a general explanation of the competency restoration and why it's necessary, and then talk about how it would be implemented according to this bill.
sure. And I may, before we even look at the bill, it's one of those
Okay.
situations where it might be helpful to hear a minute or two.
Sure.
What the lay of the land is now, and that kind of sets the stage for how the bill proposes to interact with what you already have or what the state already has.
Okay.
So currently, if a person is found either a potential danger to themselves or others on account of a mental illness, that person is generally committed to the Department of Mental Health for treatment. Right, so that's where that person would be routed currently. Now, there could be two different ways, two different avenues that person could come into the custody of the Department of Health. It could be a civil proceeding, right? Nothing to do with the criminal law, but a civil proceeding where someone can file a petition in the family division of the Superior Court. And if the court makes a finding that the person is a danger to themselves or others as a result of a mental illness, and that person can be committed to the Department of Mental Health. And that could be for hospitalization, an order of hospitalization, or an order of non-hospitalization, sometimes called an ONH. So that's one route, the civil route, nothing to do with the criminal justice system, and therefore not a forensic proceeding. The word forensic means it's related to the criminal justice system. So route number 2 is how that person could get there is through a criminal proceeding. So a person might be found not guilty by reason of insanity of a crime or incompetent to stand trial because of a crime, with respect to the crime. In that situation, the criminal court has to have a hearing to determine same thing that I just described in the family division. They're making the same decision. Is that person a danger to themselves or others? And as a result of the mental illness. And if the court says, yes, they are, the court finds that, then that person also goes to the Department of Mental Health for custody and treatment. So they're routed to DMH. That's a forensic proceeding being routed that way. Okay. So keeping that in mind for background, what does S193 propose to do? S193 proposes to take some of those people, not all of them, but some of those people that may be routed to the Department of Mental Health through the criminal division, as well as some other people who don't qualify, who are still coming through the criminal division, and have them go to Department of Corrections for treatment in the forensic facility instead of the Department of Health. Does that make sense? That's the big picture. Currently, those folks go to DMH. That's what they'd be in their custody. Proposals that some of them and some other group that isn't necessarily covered by the current law, instead of going that route, goes a different route to this forensic facility that would be operated by the Department of Corrections, not the Department. That's the big picture.
So I have a question. We used to have a forensic facility, right? Or years ago.
I don't recall. I know there was, you might call it that. I mean, there was the Waterbury Hospital, where some folks were housed. I know there, in fact, there was a mental health court in the hospital itself where some of these proceedings actually took place. I think, I just remember speaking to Judge Denport about it. I think she sat there sometime.
Well, I guess did the categories of people that you referenced, did they go into this place in Waterbury?
I think some of them did.
Okay, but not necessarily all of them.
Right.
Okay. And you have a list of what those individuals, or maybe that's, I mean, obviously some of that is the bill.
You mean sort of a description of what
Yes.
we're talking about?
Yes.
Yeah, exactly.
Okay.
Yeah.
Thank you.
Yeah. So that's the big picture. And then so I suppose the next question would be, okay, who is this slice of people that currently might be going to DMH or perhaps not going to custody anywhere, who instead is being routed to this newly created facility? And when I say facility, I don't necessarily mean a building, a new building that's being constructed. It's just a term that's being used for how they're being housed. It's up to, I think that we'll hear from the witnesses about where that would actually happen and under what circumstances, but that's the term that's being used for purposes of where they would be located, forensic facility. So there'd be two groups of people, same two that I mentioned in criminal proceedings. Could be somebody who's found incompetent to stand trial. Could be somebody who's found not guilty by reason of insanity. As I mentioned, currently, in order for those folks to go to DMH, it has to be as a result of a mental illness, that's generally speaking. So that leaves another universe of people who might be incompetent or not guilty by reason of insanity for some reason other than that. Maybe it's substance abuse, maybe it's traumatic brain injury, something of that nature that could result in the same finding. So those folks don't go to DMH currently. They would go to the forensic facility now if they met the other criteria. So look at page 1 for a quick, so you can see what are these criteria? Who might be directed to go to this newly created forensic facility? Now, the one we're talking about right now, there's two groups of people I just mentioned that incompetent to stand trial, not guilty by reason of insanity. What we're looking at first here is the competency issue. That's on page 1. So you've got 4 criteria right there. We'll start at number 4 because that's the one I already mentioned. So these are, see that found not competent to stand trial, number 4, page 1. So that's the group we're talking about. What other criteria would they have to meet in order to be sent to the forensic facility? So we'll go back up to number 1. So first of all, it has to be a life sentence, a life sentence max. So in other words, it's not just anybody who is found incompetent, and it's the same criteria you'll see later on for not guilty by reason of insanity. It's only very serious offenses. I think there's in the neighborhood of 16 or 17 offenses in Vermont total out of all the hundreds in the criminal code, upwards of 700 total, that would be someone who could go to this facility because it's only lifetime max offenses, very serious offenses. So that's criteria number 1. Number 2, they're being held without bail, or if they're not being held without bail, their release would create a substantial risk of bodily injury to another person. So again, trying to narrow this to very serious offenses. And lastly, number 3, not currently receiving treatment through an order of hospitalization. So that refers to what I mentioned, that there's this universe of people who, under the current law, they have to go through this hearing, or say they're in the criminal court, there's a question about, if court finds that they're either incompetent or not guilty by reason of insanity, they have to have this hearing to decide whether or not they're going to be committed to DMH. And if they do that, and they commit the person to DMH because they're a danger to themselves or others, then they don't qualify for the forensic facility. So if they go that route, they don't go this one. That's the setup.
Okay, so I have a couple questions there. There's an and, so it's all of these conditions, all four of the conditions have. to
Yes,
be met,
exactly.
right?
Yep.
And then it says has been charged with an offense, so they might not be guilty, but they're not able to be, go through the process.
Right.
But once they are found, if they are found guilty, that still counts as has been charged, right?
Yes, although it's a little bit different because remember, we're only talking about competency here.
Mm,
So they will not be found guilty if they're not competent to stand trial, because whether someone's competent to stand trial is this threshold issue. And if they're not competent, then they can't be tried. So that what you're describing will be the case for the not guilty by reason of insanity folks who we haven't gotten to yet. Those people are post-conviction. There's been a conviction already, or I should say, at least a finding after the guilty determination. In this case, once, whether the court notices it, defense counsel notices it, the prosecution notices it, any one of those people can raise the issue of the defendant's competency to stand trial. And if the defendant's not competent, they don't stand trial. So that's why it says has been charged with, because there won't be a conviction if the person's incompetent. There can't be.
okay, that makes sense. So then, it was said that there are about 6 people of this category already in the prisons.
I have heard that in Senate judiciary testimony, but I don't have any personal knowledge of that. You'd have to check your witnesses, I think.
Okay, okay. Any other questions? Okay, so,
All right, so that's how they get in through this route. Next page, now what happens when they get there? That's the next question, right? Well, first of all, over on page 2, you see the fact that the person ends up there. It's in this universe of people that are in the facility. Doesn't mean that their status isn't reviewed going forward. You see, they are reviewed on a regular basis. If you look at page 2, line 3, for example, every 6 months, there's going to be a reevaluation of whether or not the person's competent to stand trial. That's because, at least in the competency universe, competency is a fluid concept. It can be restored. A person can be competent at one time, not competent at another. And the entire sort of structure of this facility with respect to people who will be found incompetent is what's known as competency restoration. So you'll see that what happens in the facility is competency restoration services have to be provided the whole time the person's there. And they stay there until their competency is restored, or until they have been found that they can't have their competency restored, but they're not a danger to anybody anymore.
oh, sure, yes.
Thank you, Madam Chair. Okay, and I know this is legalese and the competency part of it.
Yeah.
So how will we know if a person is competent at the time of the offense as opposed to competent at the time of reevaluation? These are 2 completely different things now that we're talking about.
Right. It would be an evaluation by the clinical services director of the forensic facility, or you'll see later on the persons who are in the facility and are subject to these proceedings have counsel appointed by the Vermont Legal Aid.
But I'm sorry, I just, how could they go back in time and
their competency at the time of the offense is not relevant.
okay,
Competency only has to do with your state of mind at the time of trial. And the issue is whether or not you are able to understand the nature of the charges against you and participate meaningfully in your own defense.
okay.
So that's
All right.
but it doesn't have anything to do. It's interesting. The issue of competency is distinct from the issue of your sanity at the time of the offense. And that is in the second portion of the bill. If you're right, then your mental state
Yeah.
at the time of the offense doesn't change over time. It was what it was, right? That's not gonna change.
Right.
And that's why, the insanity defense is a complete defense. It's not something that will change. If you're not guilty by reason of insanity, that's never gonna change in the future.
Okay.
You may still be subject to the forensic facility. But that's why there isn't going to be, for that universe of people, you won't have competency restoration services. You'll see the language is different. They're treated, but there's no attempt to restore competency because A, that wasn't the issue, and B, you can't go back in time and change whatever your mental state was back then.
And then you just said something that, you said treated, so
Yeah.
they are continuously, getting, treatment through the time, and that's why they're in this facility to begin with. Is that, am I?
I think that's the idea.
Okay.
Yeah.
And I don't want to jump ahead of what you're gonna tell us. It sounds like this person's gonna stay indefinitely in this facility. If, I don't know, I don't know how, how they can, but it says the person shall remain at the forensic facility until the person is restored to competency or there is a final disposition of the charges against the person. So, it sounds like this person could be there a long time.
It's possible. Yep, it's possible.
And I don't know if that is the type of place where we would want this person to be, in my own personal opinion. Because I just believe that there's probably more of a need of a transition for this to happen. I don't know. I guess I would have to see more about how the treatment places would go. I can't believe that there's not a better place to treat people other than a forensic facility. We are trying to restore them to competency where, there might be a time where you say, well, you know what, this is going to take a while. We're going to transition over here. And I think that those places already exist, but maybe I'm wrong.
Yeah, I think you're going to have other witnesses who'll know a lot more about that than I will, as far as what the other medical therapeutic options are and those sorts of things.
Okay,
And, and that testing or determinant happens every 6 months,
At least,
at least every 6 months.
yeah.
And, and what is the threshold? I mean, from a, novice
Mhm.
or someone, what will be the threshold they are competent or they aren't competent? What is, I mean,
I think the question is going to be whether or not, and it's an automatic thing. Like I said, every 6 months, it's automatic. But as well, if the clinical services director at the facility, on the basis of the ongoing treatment, determines that the person may be restored to competency, they can initiate that proceeding in the court sooner than 6 months. So that's one.
because to Senator Ingles' point, this may happen 30 years
Well,
in the
I
future.
guess I'd like to ask a question of Rob, if you'd want to answer. What's the statute of limitations, on a serious crime?
Most states life offenses, there is no statute.
Okay, so this person could be around that.
Yeah, these are life offenses or murderers, rapists.
Yeah, I don't think that this is a facility that you want to be holding these people for life. When there's other places you can already hold them for life, but I do understand that.
People here, there's nowhere else.
Okay,
Yeah.
okay. Well, then I can understand that. No, but I understand that as well, so I do believe in the need for sure. I really do. So,
all right, thank you. Okay, proceed.
Yeah, so we were talking about how a person will get evaluated periodically. One of the questions that can come up at the request of a party, this is on page 2, is whether or not the person may be restored to competency at all. There are some folks who might clinically be determined that their competency is not going to be restored. And if that's the case, then what the bill lays out is that the court will keep the person committed and continuing to receive treatment unless the court finds, this is bottom of page 2 over on the top of page 3, the court could find, I mentioned this, that well, even though they might not be restored to competency, still their release isn't going to create a risk of harm to anybody. So that person could still be released into the community with conditions, and those conditions are described bottom of page 2, top of page 3, medical, psychiatric, psychological care treatment, comply with prescribed regimens of various treatment, that sort of thing. So they would have these conditions, you know, again, that they have to sort of fit in that criteria of not causing potential substantial risk of harm to anybody if they're released. But if that's the case, even if their competency isn't going to be restored, they might still be released subject to these conditions. So that brings us over to page 3. A couple of other points about that I sort of mentioned already with respect to the person at the forensic facility. You see subsection C, page 3. They remain there until they're either restored to competency. You mentioned this earlier, Senator Ingles, that either they're restored or there's a final disposition of the criminal charges. So either at some point in time, someone's going to find the person's competent, or if not, and the charges are still ongoing, then they could remain there.
Or they must remain there, right?
Sorry, they must remain there. Exactly. What's that?
Well, at that, I could,
I'm sorry, go ahead.
they actually haven't gone to trial.
Correct.
So if they are found to be competent at some point in the future, in order for them to remain in a incarcerated facility, would they have to go to trial? And then that kick in and determine whether this individual is even guilty of the charge that was brought.
I think if their competency is restored, yes, then there's the option for the state's attorney, the prosecution, to then put the person on trial in the criminal division for the original underlying criminal charge. Yeah, and so the only way they might stay there in the facility is if they don't have become competent.
And,
Yes,
yeah, and, okay, then there was a subsection that I think you just talked about, that they found that they will, in essence, would never become competent,
It's a possibility.
and then released into basically released. But if I'm not mistaken, these are incredibly serious crimes that they've committed already.
Yes, but in order to qualify for the release, they would have to have been a separate determination that that wouldn't cause a risk of danger. But that's over on page 2,
And
lines 18 and 19.
okay,
So
that's and that is obviously by the mental health professional.
Yeah, exactly.
Would determine that.
Yep.
And I find that interesting, that they can look into the future and find person will or will not commit another offense.
The court makes the determination.
By the way, yeah,
They're a risk.
right. They get an opinion from the psychologist or clinical treating person.
Lawyers, I mean.
Well, that's what the
Yeah.
provisions
yeah.
kind of predict.
Somebody had, there's some decisions. that
No,
somebody had to
I know,
make, right?
I'm
Yeah,
dismissed.
yeah, okay. So,
Yeah, back to page 3, subsection D, just that first sentence there is an important one. Person shall receive competency restoration services while at the facility according to a plan approved by the Forensic Facilities Clinical Services Director. So while they're there, they're going to get restoration services under this plan approved by the directors. That's going to be ongoing while they're there. Bottom of page 3, I just mentioned this, that there's restoration.
And I'm sorry,
go ahead.
it just clicked with something. So the judge would, in actuality, from the report that he gets from the mental health professional, if this would determine whether for the release of that, is that what you're saying?
Probably more evidence in the ESCO report.
Okay.
Who's the profession, but yes, there'd be a whole other hearing.
Gotcha.
Right. So
Okay.
look at the whole of the sentence in subdivision B, page 2, lines 17 to 19.
Maybe
It's 45. So
It'd be good for everybody to understand why is everybody turned to Senator Plunkett is because he's a prosecuting attorney. So that's why the questions have gone to him.
Thank you, that's very.
Yes. For the record.
He's not testifying.
What's he talking, shaking his beard?
I didn't start off by saying the usual
I'm not giving you legal advice.
We're glad you're on this committee. Okay,
Yes, so, very bottom page 3, these restoration services that we just talked about, they're given to the person at the facility or another location if they get discharged until they're either restored to competency or, charges are disposed of. Page 4 is all just about, well, okay, we talked about the situation where the person can be released if the court finds that, doing so, wouldn't cause a substantial risk and danger to anybody, even if they're not going to be restored to competency in the future. What you see on page 4 is just laying out a process for, well, if that happens, and then it becomes apparent to the commission that the person actually is not competent anymore, provides kind of an expedited process for them to bring the person back to the facility. Still have to make a finding. Mine's 12 to 14, page 4. The court has to hold a hearing, and the state's attorney has the burden of establishing by clear and convincing evidence the person is not competent. So it's still it's not just the commissioner can say, well, we think maybe he's not competent, and if that's what it is. No, they still have to bring him back in, then have a hearing. State's attorney has to prove that they're not. If that's the case, then they get readmitted for more restoration services. I guess, again, medical people will talk to you about this, but competency is something that can come and go sometimes. So that's why you have this track by which someone who has been released then doesn't remain competent can be brought back in if necessary. That's the idea. Let's see. So now we'll go. Okay. This is a little bit out of my expertise, but I'll point it out to you. So this is bottom of page 4, over on the top page 5. It has to do with the issue of involuntary medication. And this it tracks that there's a U.S. Supreme Court decision about under what circumstances involuntary medication can be provided. And this basically tracks that decision. Say those standards have to be met before that can be part of somebody's treatment plan. That's the gist of it. And that takes us to the end of that group. Remember, I said there's 2 tracks of how a person gets there. There's the incompetency track, and there's not guilty by reason of insanity. That's the end of the incompetency piece of it, first half. There's a little sort of intervening piece on page 5. It's a little bit related to what I just said, but also distinct. It says, I'll mention it briefly, but it's a separate issue, which is, this is basically saying that if a person is found incompetent to stand trial, and the case against that person remains inactive for a long period of time, and in this specifically, the period of time is the maximum length of time for the criminal offense that the person is charged with. If that's the case, then the court can dismiss it. So in a way, it's a method to kind of clear up some of the judicial backlog, because sometimes some of these cases, particularly if you, for example, someone's could be found incompetent to stand trial for a very minor offense, and rather than having that's never going to go anywhere, the court case has been sitting around for a long time, just provides the court with the ability to dismiss those cases. So it's kind of a separate issue, somewhat related in the sense that because it's dealing with the competency issue, but not very the correcting facilities.
right, and this is misdemeanor, so that wouldn't be something that would be.
Yes, exactly. Misdemeanors. All right, so that brings us to group number 2. This is over on page 6 now, of people who could end up in the forensic facility. And you see, these folks are people who've been found not guilty by reason of insanity. So this is talking about a person's mental state at the time of the offense, not at the time of the trial. And the insanity defense at the time of the offense means that the person either couldn't understand that their conduct was criminal, or they couldn't conform their conduct to the requirements of the law. So even if they did understand it was criminal, somehow they were unable to act in a lawful way. So either one of those possibilities for supporting that insanity defense. And if a person is found not guilty by reason of insanity, and this is line 6, page 6, of an offense punishable by a life sentence. So again, it's a very narrow group of offenses, again, very serious offenses. Then that person it goes to the forensic facility pursuant to this section. So in this case, there aren't any other criteria other than that. So if you were found not guilty by reason of insanity of an offense punishable by a life sentence, then you go to the facility. and again, in this case, it's not going to be any competency restoration process because it's not a competency issue. It's all to do with your mind, your mental state.
It's already at the truck.
Yeah.
In that. So, and it, so that the 6 months is out, they don't get, because there's no competency at that point.
Right, although there is still an opportunity for the person to petition to have their mental health status reviewed, because it could be that they might no longer present a danger to somebody, so there is an opportunity to have the court review that. So they might not necessarily stay there they can ask the court to review it. And there's the same process that I mentioned earlier, where the clinical services director, if they become aware that the person no longer has a condition that would cause substantial risk of injury to people in the community, they also have to go to the court and say, we think things could change for this person to go.
So this is new language.
Yep.
So what
Yeah.
was the language, or what is the current language?
Well, there is no forensic facility currently at all. So the only current sort of structure is the one I described in the very beginning, which is that if a person is found not guilty by reason of insanity, the criminal court has to have a hearing to determine whether or not the person is a danger to themselves or others as a result of a mental illness. And if the court finds yes, then they go to DMH. That's the current
Okay,
structure.
okay. Thank you.
But this proposal is provides a different avenue, so to speak, for some of those folks. Not all of them, because it has to be a life sentence for one thing. Well, I guess primary criteria for the NGRI people. NGRI is not guilty by reason of insanity, FYI. For those of you who didn't know. But that's a nice acronym because it saves a lot of verbiage. So what happens when that person then goes to the facility? You'll see subsection B, page 6. In this case, there has to be a hearing right away within the first 40 days. And at that hearing is when, and there could be a forensic risk assessment. There has to be actually a forensic risk assessment provided to the court at that hearing. And then that's where you go around to page 7 now. That's where the court makes the decision about whether the person is going to be committed to the facility. And what happens is the state's attorney, this is line 4, page 7. The state's attorney has the burden of establishing by clear and convincing evidence that the person is suffering from a qualifying condition that upon the person's release would create a substantial risk of bodily injury to another person. So in other words, state has to show with evidence that the person has a qualifying condition. That's one part of it. The other part is this qualifying condition, if the person is released, there's be a substantial risk of bodily injury to somebody. So the obvious question is, well, what's a qualifying condition? Right? That's what we would, we'll get to it in a sec, but just so rather than, on page 10, lines 18 to 20, any condition, whether mental, congenital, or traumatic, however acquired or developed, or any other circumstance that resulted in the person being determined incompetent to stand trial or not guilty by reason of insanity. So you see, it's broader than mental illness. That's the one of the primary differences between the proposal and the current law. Current law, it's the universe of folks that can go to or that are committed to DMH if they're found or to be dangerous to themselves or others is on the basis of a mental illness. So this is broader than that. It could include other conditions. So that's another way that the proposal kind of expands the universe of people who might go to the forensic facility. All right. So the court, as I say, the court has here within 40 days. The state's attorney has to establish by clear and convincing evidence the threshold question about the person having a qualifying condition that could be dangerous. If they haven't, and this is page 7, line 8, the state's attorney has not established that, then the person gets released. So the state's attorney has to establish. If not, the person gets released. Now there are conditions that could be attached to that. That's the case. So a little bit different than what you saw in the competency post, but important piece. subsection C, placement of a person at the forensic facility shall be for an indeterminate period and shall not have a specified end date. Now, in this case, the person cannot be released until, this is that same language again, line 16 to 18, until they're no longer suffering from that condition that would cause this risk of bodily injury to somebody else. Now, again, as I mentioned earlier, the court is going to have to regularly review that question. It's not that they're there and then the court never looks again at the question of whether or not the person has this condition or is still dangerous. The clinical services director has to let the court know if they ever think that the person doesn't have those criteria anymore. That's one way that the court would find out. Second way is that the person can file a petition every year to reevaluate their status. And if at any time on the basis of those petitions, the court finds the person doesn't have the condition anymore, or the condition doesn't cause this dangerousness, then again, they can get released conditions. So that's kind of the big picture. I know there's a lot of language there, but that is the essence of it. If there's anything else I'd want to flag for you. There's a similar kind of process that I mentioned in the competency context over on page 9, top of page 10, page 8 and 9, where the person can release the person the court can release the person on conditions. But then if they see that the person is violating their conditions, there's an expedited process to bring them back in again. That also exists here. Over on page 10, subsection G, crime victims have a right to appear and express their views concerning person's placement. Page 10 also has as where section 4 starts, which is the definitions. And this kind of brings us to the point about the Department of Corrections being the authority here. This is page 10, line 12. Forensic facility means a locked facility or placement that the Department of Corrections provides for the security violation of treated persons in the legal system, who we've been talking about. Qualifying condition, we just talked about, on page 10. Page 11, line 5, subsection B, is the directive to the Commissioner of Corrections shall establish and operate a locked, secure forensic facility for the secure evaluation, treatment, and care of persons who have been transferred pursuant to subsections 4815A and 4819A. Those are the two sections we just looked at, the incompetency and the NGRI. The last sentence of that, lines 10 to 12, all forensic, clinical, and competency restoration services provided at the facility shall be overseen by the clinical services director. Page 11 over on is really just talking about that the records are generally confidential. Records of treatment at the forensic facility generally confidential. A couple of exceptions. The parties in the underlying criminal case can see them, and the person's other healthcare providers if the person consents.
So if
Yes, go ahead.
Thank you. So and I guess this is maybe Department of Corrections, do we have the physical structures currently, or are they going to be put into a building that is, or a facility that is already correct?
I'm going to defer to DOC on that. I think they'll have your much better answer than I could give you.
Yeah, well, let's talk about that after we hear from the Department of Mental Health.
Okay,
You know,
sorry.
because no, that's a really good question. And that's actually a fundamental question of this bill.
Well, we're just about done with the walkthrough. That was last page 12, this couple of last points. And I already mentioned this, page 12, lines 3 and 4. The people who are in the facility and are subject to these proceedings get attorneys appointed by Vermont Legal Aid. See, that's lines 12, lines 3 and 4, page 12. Although the Commissioner of Corrections is the one who oversees this facility, subsection E of line 12 requires the Commissioner of Corrections to regularly consult with the Commissioner of Mental Health for purposes of the facility. And last couple of things that the EOC is required to adopt rules to implement this section. So there'll be a rulemaking process. Rules will come back to the legislature through the administrative rules process. And lastly, in these competency restoration proceedings and related ones, which is the last section, that the rules of evidence generally do apply. So again, listen to any relevant testing.
Thank you. I just have
Yeah.
one, I think I just have one on page 11.
Right.
Commissioner correction establish and operate a locked secure facility.
Right,
The forensic facility shall not refuse any persons it is ordered to admit and shall not require any clinical or diagnostic prerequisites for admission. Is that standard language? I haven't seen language like that.
well, I think this is specific for this forensic facility, yeah.
Okay.
Yeah.
Okay. Okay.
Yeah, I think that's, but thanks for bearing with me, it's a lengthy bill, a lot to
thank
it, with the, yeah,
No, I appreciate it.
Yeah.
We appreciate it.
yeah, absolutely. Well, any other questions, let me know, for sure.
Okay, thank you.
You bet.
Okay, so next, we have Karen Barber. Thank you for being here.
Yeah, thank you. Good afternoon. For the record, my name is Karen Butler, General Counsel for the for the Department of Health. I've never been in front of your committee before, so thanks for having me. I've been General Counsel of DMH since 2014, and I have been working on forensics in one form or another for about a decade.
Wow.
So even though this is not a mental health issue, this is a human services issue, I tend to be the person testifying just because I have the most knowledge on it, but we have lots of people here from AHS to talk today. So I had some points, but in hearing your discussion, I wonder if I might back up a little bit, because I think when you're talking about why corrections, it might be helpful to understand the DMH system a little bit to explain why it's not DMH. So if it's okay, I'll start.
Please, yes, thank
Okay.
you.
So, and I think it gets to your point about that language. So the Department of Mental Health is a healthcare provider. Our job is to provide for the mental health care of Vermonters. We do that in multiple different ways. If someone is involuntarily in our custody, that means, as Eric has said, that they have been found a person in need of treatment. And that means that they've been found to be a danger to themselves or others due to mental illness. There are two ways that we treat folks who are involuntarily in our custody. One is through an order of hospitalization, and one is through an order of non-hospitalization. An order of hospitalization is what it sounds like. They are involuntarily put in one of our hospitals on an inpatient unit. We have 6 of those throughout the state. We have a decentralized system. We had the Vermont State Hospital back before Tropical Storm Irene flooded it. And after that, the legislature decided to create a very different system. So we do have a state hospital, that's VPCH, or the Vermont Psychiatric Care Hospital in Berlin. And then we have various private hospitals throughout the state that also take folks, including Rutland Regional, Bradford Retreat, UVN, Springfield, the Wyndham Center, and the Veterans Hospital. All of our hospitals in Vermont are CMS certified and Joint Commission accredited. So what does that mean? That means that in order to be admitted to one of our facilities, you have to have a mental illness that is acute enough that it requires inpatient hospitalization, that there's no less restrictive alternative. And only an admitting physician can make that decision. So a court can say, I want someone to go to the hospital, but a hospital can say no. DMH also doesn't have the authority to place them in the hospital, even our own hospital, because again, you're also CMS certified and Joint Commission accredited. So only our physicians make that decision. That is why that language is in there, is because there is a desire often to have people go, because to your point, our hospitals are the only secure facility other than DOC, and for a very small population, River Valley, which is our secure residential. But there aren't other secure facilities. So there is a desire often to put people, including people who are accused of committing the most serious crimes, into a lab setting. Our system doesn't allow for that because of the way we are licensed and accredited. And so the idea behind this is to help fill that gap. If someone is in our custody but doesn't meet criteria to be in the hospital, they are under what's known as an order of non-hospitalization. Those are community-based orders. Other than the very small population at River Valley, those are folks that are just in the community. They're not in secure settings. It's not housing. And really the idea behind an ONH is the black robe effect, right? Like a judge is telling you you should do something, you may be more likely to do it. So engage with treatment, take your medications, comply. Mental health treatment is not punishment. We do not punish people. The goal is to get people to engage so that they can be successful in the community. That is very different from a public safety, criminal justice perspective. They are not like conditions of release or probation. If you do not comply with your own age, you don't go to jail and you don't go to the hospital. Only go to the hospital if you actually need to go to the hospital. And it's just like if anyone went to the ED with a stomach ache and said, I'd really like to go, I think I'd feel a lot better if I got to go in a hospital unit, and the physician would say, no, you don't need it. It's the same with mental health. Just because someone has a mental health diagnosis doesn't mean they need to be in the hospital. It's a very high clinical bar. So that's kind of how we got to where we're at today. We also, even though we are not a party to criminal cases, DMH is responsible for doing mutual competency evaluations. So that's why we know a lot about competency evaluations. We have a contract with forensic psychiatrists who do these for them. They're not state employees. People are found incompetent for many reasons other than mental illness. Substance use, TBI, dementia, developmental disabilities, intellectual disabilities. All of those folks are not eligible for DMH services. And so, as Eric said, if someone is found incompetent or insane for reasons other than that, other than mental illness, they can't come into our custody. So there is no place for them to go. It's a large gap. You hear about it a lot. That's the gap we're trying to address here. Where do we put individuals that do not need to be in the hospital, but still have clinical needs and are a danger to public safety? And so that's really what we're trying to address here.
So are you okay with questions as we go along?
Absolutely.
So, where are those people now?
Hence, some are already in corrections. Some, because of the way our statutes are written, if you're found incompetent, you can only remain in corrections for so long. So then they're in the community.
So how many of them are there? And who are the ones? What's the category of the ones that are in corrections now?
I think when we looked, we think we're talking about 3 to 6 people a year is about who we think. This is a very small population. It's very narrow, right? You need to have been accused of committing very serious crimes and held without bail. So we're not talking about a large population. We're talking about the crimes that you hear a lot about and folks that aren't in our hospital system because they don't qualify to be in our system.
But then, so the people who are not in corrections or not in your system, who could be in corrections, what is the total, like just an estimate of that amount? Because that's the gap, right? The people who are falling through the gap.
Yeah, so the people who are in corrections can't remain in corrections, and so that's part of the problem. So they may be cycling through, right? So by statute, you can only stay in corrections so long if you've been found incompetent. I think we have found judges that have been creative about how they do that, because there's a desire, if someone remains a public safety concern, to not have them out in the community. And because we don't have any secure locations, so I don't have, exact numbers in front of you, but those are the numbers we're thinking, probably 3 to 5 a year. There are certainly folks right now that are in corrections that would fall under this. The other thing we see, and part of why there's some language in there about if you become incompetent after a while, is we see people cycling. So we don't have a competency restoration program in Vermont. We're one of the only states without it. So if they are sent even in the hospital, we're not working to restore their competency. It may be a result of treatment. It may not be. But sometimes we see people that are restored that become incompetent again, and there's a cycle. So they're not going to trial because they're cycling through. So corrections, the community, the hospital, because they can never really get to the point where they're maintaining long enough to go to trial. And so part of this too is that we're trying to help stop that cycle. And guilty or innocent, people have a right to go to trial, right? It's one of our fundamental constitutional rights, is to be able to go and prove your innocence. And so we want to work to be able to get people to do that.
Go ahead. Just in that.
So there's no facility now, correct?
No.
Okay, so I'm having like a moment here. Let's tee this softball thing up for Major to tell me later on. But I was with a group 2 years ago. It was Senator Kitchell. It was myself. It was Chair Evans. It was Chair of Judiciary. And we identified a brand new building in Essex that didn't have, that wasn't using 8 beds. And we put this forensic facility together at that point in time. What building am I talking about? We were there, we did it, we had the money, we funded it, we had the building, we had the site, we had everything. And it was a forensic facility.
So I wonder if what you're thinking of is River Valley, which is our secure residential that is on the site of the old Woodside. So when they raised Woodside, we put it there. River Valley is not a forensic facility. It is a mental health facility. It's licensed as a therapeutic community residence.
This wasn't that.
I think it is though, and I'm saying that because there's been a lot of confusion about it. You're not the only one that has said, I thought we did that. And what happened was 2 years ago, we spent almost all session talking about a forensic facility,
Yes.
and we got very close. And at the end, it became very clear that it was not going to get through the House policy committees. And so what we did was say, okay,
We brought him in and we got him.
no, we're not gonna get that.
that.
But what we could use, if you're still open to making some changes to statute, is we could use the ability to do seclusion and restraint and involuntary medications at our secure residential, which is something we didn't have before. It's something we had asked for originally when we built the facility. And at that time, again, there was a policy disagreement in the policy committees, mostly on the House side, about whether or not it was okay for us to do those things. And so they weren't in there. So what happened was we spent most of the session talking about a forensic facility. And at the very last minute, we ended up not doing that. But we did make changes to a DNH only facility. And so I think that is where people get confused. It is not a forensic facility. It is paid for in Medicaid
I know
dollars.
exactly where you're talking
Yeah,
about.
but that's what
got it, but we pounded out a deal and we had the site, we had it, it was there. We were there for 2 hours, 3 hours, and we were running people in and running people out. We had the funding, it was right at the last minute, and we had it, and it was done. And I just don't know what happened to that. And it was a forensic facility, exactly what we're talking about right now. And I will keep on digging, and we'll find out what's going on, but I know.
So let me ask a follow-up question. So would the constraints that you referenced, would that have made it a forensic facility? Or able to be used as a forensic facility?
So we never supported River Valley as a forensic facility. That was never an option that DMH had put on the table. If you attempted to do that, we would lose all Medicaid funding for that facility.
Because of what else goes on there? Is that the problem?
Correct. So the federal government will not allow us to use Medicaid dollars for anything to do with criminal justice matters. Right now, the only people that go to River Valley are folks that clinically meet that criteria. So they have mental health needs that they no longer need to be in a hospital, but their mental health needs are acute enough that they do need a 24/7 secure facility. So again, it is licensed as a therapeutic community residence. It has round the clock nursing and psychiatry coverage. And so we did make changes to it to allow us to take more acute folks, but those are only folks in our system.
Okay.
Yes.
And Senator Major,
You said there was a term that you can only keep these individuals. Do we know what that term is, or is it dependent upon what the courts say?
In our facilities, DMH facilities.
You were saying that there was the term, the people who are found mentally incompetent, that you can only hold it for so long.
Oh, in correction.
Yes.
Yeah, it's in statute. I forget
What
this.
statute is that? That's the first time I'm hearing.
I forget to say, we actually extended the timeline.
Either. Yeah.
Yeah, we
I don't
actually-
think that exists.
It does, because we actually changed the timeline from 14 to 21 days a couple of years ago.
No, I would absolutely
Because
love
it's an
to.
issue. It's something that Vermont is an outlier on. Most states don't have that, but it is a real issue because it means, I'm sure it's in Title 13. I don't know off the top of my head.
The corrections is be 28.
Oh,
It's correct.
I can't remember. I thought it was under the,
It's specifically about competence.
yeah. In our system, physicians make determinations.
Okay.
So we have to discharge someone as soon as they no longer meet the clinical criteria.
So there's not a specific time, but it's
It's
determinant.
Yeah,
Gotcha.
but only in, again, only the physician. will
Okay.
make that determination.
Okay, thank you. Okay, Senator Patch.
I just want to go back to something you said earlier, it's so clear. You don't operate any secure facilities, is that what I heard you say?
No, we do. We only operate secure mental health facilities. So the only, so involuntary hospital units are locked.
Okay,
And River Valley is locked. All other facilities are open. So we have, so people on orders of non-hospitalization in the community could be living on their own. We have many residential programs that are staff secure, meaning they're staffed 24/7, but if someone attempted to leave the facility, they would not be stopped. Even our facilities, due to our licensing, if somehow someone was able to elope from our facilities, we could actually not stop them from leaving once they got past our property. We would have to call the police because of the limits of our license.
Okay.
So all that to say, that is our system. Those are the gaps. So the gap is that one, not everyone who has a mental illness requires hospitalization, and thus there is no secure location for them. And two, there are many people who are found incompetent for reasons other than mental illness, and there is no location for them. So what we're attempting to do from this, and we have been, as I said, we've been trying to convergence of forensic facilities for about 10 years now. This is the narrowest we've ever tried. We've really heard a lot of the feedback about the concerns, and we've really tried to narrow it very, very narrow. So it's only people accused of the most serious offenses. We're facing life sentences. And there are, as Eric went through, there are ways that if they are no longer a public safety risk, that they can be discharged into the community with conditions. So we do feel that this strikes a balance, but it is for three of the priorities of the administration, which is protecting public safety, upholding due process, and ensuring people have access to appropriate treatment. So we have done a lot of work. We had a forensic work group several years ago. We've looked at other national programs. We are not attempting to create some large forensic facility, but instead a really narrowly tailored facility focused on best practices, which is focusing on treatment and accountability and public safety. And so we really believe that this is an important thing for the legislature to move forward because it is a gap in our system. I think it also shows a cross-agency approach. So even though it says DOC has to consult with DMH, we had asked for AHS, find whoever it says, because it's all of AHS. And so AHS is going to be working together on this because it's not just DMH. It's also the Department of Health and their substance use program. It's the Department of Disabilities, Aging, and Independent Living. And so it's all of us working together to make sure that folks are getting the treatment needs met, but also we're able to really focus on their safety. So we strongly support this bill, and we support it as well.
Okay, so I just have a couple questions. So the folks in corrections, they're there temporarily, and people are saying 3 to 6 people, but that's 3 to 6 people per year. So is it accurate to say that that would be the incoming folks? I'm just really trying to get a sense of what sort of facility, how many square
Yeah.
feet,
So
how many people would need to get?
yeah, so we think,
Sure.
3 to 5 people a year, but remember, if you're coming in through the competency door, the idea is that you're restored to competency and then you go to trial and you're not that you're not remaining in the forensic facility, that you're being restored and then you're going along your process. There are folks that are going to be unable to be restored. We know that. I think it's going to be a really small number. But again, there's an avenue in there that if they are not a danger to public safety, that they could be released on conditions. Same with folks that are found in confident or not guilty by reason of insanity. So I don't think you're gonna see every year building and building and building. I think the idea is that, you know, folks will be restored to confidence and go on their way, and eventually folks will be able to be stepped down to lower levels of care. We still, you know, the goal of, we always, you know, we're under the ADA, so our job is still to make sure that we're serving people in the least restrictive environment possible. And so that is the goal. And there's an understanding that for some folks, there are real public safety risks, and there does need to be a secure setting. It's hard to say exactly how many because we don't have a competency restoration program. So people aren't being restored, right? They're just kind of stuck in this cycle.
Right, but somewhere there's gotta be some estimate. I mean, I'm thinking like 10 to 30 people or something, but there's a amount of space that you would need to have a place like this.
Mhm.
And our prisons are overcrowded. You probably have heard from, I hope you've heard that. So what kind of space needs are there, and what would the space be like? I would think in addition to being secure, you'd want something restorative and not punitive.
Yeah, so again, DMH wouldn't be running the facility, so I can defer these to DOC, but an agency as a whole has worked together to kind of consider these questions, but those are probably questions best left to DOC.
Right, but your area, that you folks would be determining the type of care that would be.
No, so again, this one isn't all about mental illness, and so we don't provide services now in corrections. That would be WellPath or whatever contractor they choose. So DOC, just like they do now, because they are providing mental health services in corrections now, along with substance use and TBI and dementia. So they would continue to provide all those services through WellPath or whatever contractor they chose to do that.
Okay, so what would the clinical director, is that the term?
Yeah.
Wouldn't the clinical director be someone with your skills or somebody in your area of profession?
It would be a clinician, best determined by DOC and WellPath as to what level of clinician would need to oversee that type of facility, whether it be a forensic psychiatrist, a forensic psychologist, whether it be some sort of other type of, you know, they have clinicians already now in corrections, again, doing this work. So I think, again, they would also be best to talk about what type of clinician they're.
And we can get them back in. So then the person charged with an offense punishable by life sentence found not guilty only by reason of insanity, those go to you now. That's what I heard.
No, not necessarily. So
Or
again,
DMH.
no, so there's a path where they could. And so I think what Eric was trying to say is they could, but many of them don't, and that's the gap. So they can only come to us if they are a danger to self or others due to mental illness and they meet that criteria. Many of them don't. Frankly, we don't have a lot of folks that are found NGRI because we don't have a competency restoration program. Most people don't get to trial. Usually there's issues of competency and sanity, and so we don't see them. The folks that we do see, sometimes they're on an order of non-hospitalization in the community. It's very, very rare. I can't think of one off the top of my head in the last several years where someone who's been found NGRI actually goes to the hospital because, again, sanity is at the time of the offense, and by the time they've either been found competent or got through the trial process, it could be years. And sanity also doesn't necessarily have to do with mental illness. So maybe, but not often. I mean, that's the gap.
Okay.
Just, I know I'm trying to figure out or estimate how many people. I mean, that's sort of important to understand what you're trying to accomplish, but also the mix in terms of male, female, because we know we have real problems right now with the women's prison. So is this going to be a unisex facility we're talking about, separated? What's the vision here?
I think that's a question that's answered by DOC.
Okay,
You had talked best practices in other states that were doing, what are some of the other states and that has something similar? How have they fared?
Yeah, so I think when you look across, no state does it the exact same way, and many states frankly probably don't do it all that well. When we were looking at those practices, there's been a lot of work by the National Center for State Courts and one other organization that I'm blanking on. And so they kind of looked across. We submitted a report on the forensic facility, I think actually 2 years ago when we were doing that work. And it kind of details all of those best practices and goes real in depth on the data about competency restoration, the different models. One of the big things they recommend is only limiting competency restoration to the most serious crimes where there's the most compelling state interest, which is what we're trying to do. And the other big thing they recommend is not focusing just on restoring somebody to competency in terms of do they understand that proceeding is against them, but also making sure you're meeting their clinical needs. So in many other states, so competency is a legal term. It's not a clinical term, right? So it really has nothing to do with what your diagnosis might be. It's, do you understand the charges against you? Can you work with your attorney? Do you understand what could happen? So in a lot of other states, they're just teaching those things, right? Like how do you include your lawyer, and they'll go through. And so the best practice, they say, is to also couple that with treatment that makes sure whether it's substance use, whether it's a TBI, whether it is some sort of lower level mental health issue, that you're addressing their clinical needs as well as making sure they understand the process so that they can really best, be able to go to trial. And also the goal eventually is for everyone to be productive members of society, right? So how do you set them up for success? You make sure that they're getting their treatment needs met. So those are the two things that we've really focused on.
okay. If you can send us that report, that would be helpful.
Yes, again.
Um, all right, I think that's all the questions I have for you, but thank you very much for being here again on short notice.
Yeah, no
Really
problem.
helpful. So now Steve Howard.
DMC is here if you wanted.
Yeah, I didn't know if you are you prepared to testify or?
I can answer some of the questions that
Oh,
are lingering for you.
Okay, yes,
Like,
please.
Madam Chair, thank you. My name's Lori Fisher. Go ahead, Mr. Harper.
I'm
but-
sorry, I didn't.
No, that's okay. That's all right. Sorry, Nancy.
Sorry.
I'm Lori Fisher. I'm General Counsel for the Department of
Oh, okay,
Corrections.
okay, right,
So-
we did meet, I apologize.
Yeah, no, that's okay. It's all right. You meet a lot of people. First, I think the statute that we were referring to in relation to the 21 days is 13 VSA 4820.
Yeah, I found it.
Okay, okay. I wanted to make sure.
It's whole pending the hearing on whether they should be put in DMO, which is not told, but I understand your, under interpretation of it. That's not. But anyways, yeah.
Okay.
Okay, yeah, so if you can stick around, that's great.
Okay,
Okay,
perfect.
okay, so Steve,
Good afternoon.
thank you for being here.
You're welcome. For the record, I'm Steve Howard. I'm the Executive Director of the Vermont State Employees Association. Madam Chair, on this issue, on the issue of forensic facility, the SEA has somewhat of a nuanced, it's clear. We have a clear position, but it's also nuanced because we represent frontline workers at the psychiatric care hospital and at Riverside, but we also represent the frontline workers in the Department of Corrections. So let's see if I can do this. So VSEA has long supported a secure forensic facility. And the reason we have supported that is because our members at the psychiatric care hospital believe that there are folks in their care that are in an inappropriate setting and should be in a setting that is more conducive to security. Our members in the correctional facilities often, as you heard from previous testimony, are supervising offenders who are in a facility that they believe is also an inappropriate facility for them to be in. They believe they should be in a more therapeutic, more hospital-like setting. The VSEA's position is, yes, build a forensic facility. It can be with the Department of Corrections, but don't build it in a correctional facility, and particularly don't build it at Southern State. Southern State is under a tremendous amount of pressure, and you've heard my testimony in this committee before. Department of Corrections is teetering on the edge of a huge crisis. And we feel it's not, Southern State is not immune to that crisis. One interesting question that I would ask the Department of Corrections is how many times in the last year has the department, or even the last 6 months, has Southern State been in a lockdown or in a partial lockdown because they didn't have enough staff? You heard testimony from the commissioner that staffing is getting better, and oh great, we've gone from like 30% to 15.5%, but that's overall staffing for the department, including central office and field offices. The question you really want to ask the department is, what's the number for CO1s? Because those are the folks who are CO1, CO2s, their supervisors. Those are the folks who are actually in the facilities who have the offender or have the person that's the subject of this legislation right in front of them. And that's where we're in a serious crisis. And you saw that in the Prim report, where repeatedly you heard the folks at Southern State say that mandatory overtime is a serious issue. 84% said it's a serious issue. Frequent turnover, also 84%. So that facility in particular has, I think, demonstrated through comprehensive research through that process that they are at the breaking point. And adding additional pressure to that system would be inappropriate. Now, that's not to say, on behalf of our members at the Psychiatric Care Hospital Riverside, that we shouldn't be building a secure forensic facility, as we have long advocated. Just not at that facility, and potentially not at a prison. Could be supervised by the Department of Corrections. The one caveat I would say is, from VSA's members' perspective, because we are so close to a serious breakdown in the Department of Corrections, losing a unit or losing a facility because we don't have staff. We believe strongly, and we've advocated for this, that from the governor on down, this should be the only issue the Department of Corrections is focused on. This is the issue that almost nobody is addressing in a way that our members believe it should be addressed, with the kind of urgency that it requires from the top CEO of the state on down. That's not to say they're not trying and they're not doing good things. They are. But this is a gubernatorial level crisis that is not getting gubernatorial level attention.
Okay, are we talking about a forensic facility, or we just kind of crash everything here? Because I'm not gonna stay around in this.
Well,
Just not.
I
So,
think it's just the
Okay.
amount of
okay,
the,
I've heard
personnel.
enough. I really have.
all right.
I have heard enough.
So I appreciate the ability to give the testimony that our members have asked us to give, particularly at Northern State, where they are also at a serious crisis, even worse than Southern State. And if Southern State had additional capacity, it would be to the benefit of Northern State to get relief from that facility. And I raise that issue only because if you're adding additional burdens to the department, you have to add it in the context of the serious staffing crisis. And so that is, I think, an important testimony that people may not want to hear, but it is the truth. And so we have to bring that forward in the context of the discussion you're having here today.
Okay, thank you. I appreciate that. Anyone have questions? I was under the impression that when we were there about a month ago, that things were starting just a tiny bit.
You would never know that. You would never know whether it got better or not with this guy. You never.
No, I was there myself.
I know,
That's
but
why
you would
know
never
myself.
know. You
All
would
right,
never
well,
know if it was ever good.
okay.
So.
So Madam Chair, all I can report to you is what our members report to us.
Yeah.
One thing I'd also ask is, how many times in the last year has the Everbright system been used, where messages are sent out across the department saying Southern State is in serious need of staffing help? Those are factual data. In fact, I think the SEA has presented a list of questions that we encourage the legislature to ask the department for, data-driven information that will tell you exactly what the truth is, which is consistent with my testimony and can be confirmed by our members at all the correctional facilities, Northern State being the most severe of all of the facilities right now suffering from a staffing crisis.
Okay. Understand. Thank you. Any questions? All right. Thank you very much
Thank
for
you.
being here. Appreciate it. Okay, so Ms. Fisher, are you available to, or if you want to, or you can come back another day?
No, that's fine. I don't have anything prepared. I'm here to support
Well, just
my
the
colleague
answer.
who's the expert on the TMA. Specific to, which is like, after Mr. Howard has talked, Southern State, we currently take care of these folks. The GAP population that we're talking about, they're in our care and custody right now. And we have very skilled staff, that take care of them in conjunction with the folks at WellPath.
Which unit are they?
Either Alpha or Bravo unit at Southern State. That is primarily where.
Yeah, just, because I don't know if you should actually testify on this, or, well, some of this you can testify on it, but okay, go ahead.
So when we're talking about facility, I'm just here to tell you that we're not asking for creation of anything new. It's what we're already doing, and it's a very small population. We do believe that I didn't check the numbers this morning in coming here, but it was 6 on last count that would fit this criteria currently. And they have come in over a series of years. So when you talk about, I wouldn't anticipate that would be 6 yearly, but over, a period of time, probably averaging one to 2.
So are they getting the level of care that's anticipated in this legislation?
They get a medical standard of care. There's no competency restoration.
Or not comprehensive restoration, but this has requirements on how they're cared for.
Well, again, the Department of Corrections, how often we're critiqued, but we receive orders on what we're supposed to do with individuals, and we're supposed to work in conjunction with DMH. We get minutes from the court on how people are supposed to, what their conditions are, how we care and treat for them and supervise them, what programming they require. And so this would be along the same lines as to what the determination was. If we knew what the competency was, we certainly have the restoration people in place, which is, I understand WellPath has been, that they operate forensic facilities around the country in this manner. They're are already doing this in other places, so they can better speak to what that looks like from a clinical point of view. But we're accustomed to taking orders and moving accordingly.
Okay, that's helpful. So we will get WellPath in. Do you have physical space for additional people?
Well, I mean, the classification of individuals and how they move in and out of our system varies obviously from day to day, depending on. So there are days that we're, at a critical level in relation to the buildings, and there's other days that we're well under, what capacity is. There's only been one lockdown at Southern State since I took over the general counsel role in the manner that Mr. Howard described, and that was since October. So there is improvement on staffing in the way the commissioner previously testified. So overall, we do what we need to do with what space we have and take care of the individuals. Our goal is to not have individuals. You hear a lot of testimony, I think, with people on what we call boats on the floor, sleeping on the floor. We try to avoid that. But this bill also allows us the free flow of individuals to move them around, if that's ultimately what is ordered that they need for restoration. So,
and there's no additional funding that I see. Maybe that's a future process. I don't know.
Yeah, I think AHS, the suggestion here is to first figure out the gap population, and then determine what it's similar to the SUD stand up that we've done in relation to the accountability court is adding clinicians to provide the services that these individuals need for whatever reason they need it for. So
you'll figure out what it's going to cost later. Is that what you're saying?
well, I mean, it's difficult to determine exactly what we need for clinicians until the parameters of the program are laid out. I can just verify for you that we're minus the restoration actual clinician piece, we're already taking care of these folks and from a public safety perspective.
Okay. Oh, yes.
And just in terms of the rulemaking, which I assume will lay out a lot of the details of what we want to answer right now, how long would you anticipate that rulemaking to take? You can ballpark it. Decades?
No.
Years?
No, I would say within a year.
Okay.
We have a good start on that based on the initiatives that have, we've been asked to do lately. So we have a good framework for that and, a good relationship with our, clinicians on how to build that. And again, they have and I think you'll hear from WellPath more details that I think will help you understand better that I can't speak to. But they have it all structured. They know, what is needed and how to implement that. So we'll have a good head start with that.
All right. All right.
Yeah, I sort of had that same question, and it talks about a time frame in here by January 1 of 27 to have an emergency kind of plan in place. And I just was curious whether that gives you enough time to actually be ready for this change.
I believe so. I do. I believe so. A lot of the variables that we can't answer are primarily based upon what the individual needs and what the expectation of restoration would be for them. So, but it's to get from here to that, I think we can do pretty quickly.
It would be, Madam Chair, be interested to hear from WellPath, and going back to Senator Ingle's question back in the beginning, is what does the facility really need to have to properly treat these people so that we're hopefully successful? And what I hear you saying, and I don't want to put words in your mouth, but that you're dealing with some of this already in the current prison setting. And so I'm just sitting back going, is the current prison setting the appropriate facility? Or do we need to be looking at maybe not right off, but planning for some changes, maybe not all the way to a brand new facility, but a wing or something that is set up for these folk, for the type of atmosphere they actually need to thrive?
Those are many of the questions that we've been discussing and brainstorming on what that looks like and what the needs will be. I think if it's someone who needs supervision to take their meds and keep them focused on that, as an example, that is something that I think our current system can handle in a way. If it's something more therapeutic that they need. I understand your concerns about allow cinder block prison to be a place to do that. That's fair. But I think that is something we can work toward as we develop this.
Yes.
Just one
Yeah.
follow-up on that. Sure. There's current planning going on for a new woman's prison. So in the light of some of this, I don't know what your, conversations with BGS have been, that we don't want to forget about this part in the overall planning.
I appreciate that. I don't want to overstep my lane here. I'd love to talk to you all day about the women's facility that we need desperately. But yeah, if there's any conversations that I've been part of have been global in relation to needs. It doesn't personally to me make sense that we would talk about a new facility without looking at the entire unified system and what the needs are. For sure.
So have you had women, folks of this category at the women's facility?
I believe we had one individual that I'm aware of. Currently, I don't believe that we have a female, but I'd have to verify that. I'm sure.
Okay, thank you. All right, well, we'll definitely talk to DOC some more, so thank you for being here.
Thank you. Appreciate the time.
So, Dr. Lip, you, please come sit, but I want to be very clear, I'd like you to explain, who you are and your background and who you speak for and who you don't speak for.
Right.
And then I want the committee to understand before we hear your testimony, okay?
Yes, my name is John Letman. I am a physician and work in the medical staff at Southern State Correctional Facility. I am here essentially on my own behalf, partly at the request of Senator Harrison. And I am emphatically not pretending to represent WellPath nor the Department of Corrections. I'm really not authorized to do so, nor really, I think, am I qualified to do so. However, I do have a pretty close knowledge of what goes on the ground in the care of the medical care of people at Southern State Correctional Facility. And I think what I've been hearing with this leads me to sort of ask the committee and challenge the committee with what the legislature's intent would be in monitoring the development of the facility that aspirationally has been described in this piece of legislation. But that, just as we have just been hearing, there's a devil in a lot of details in bringing such a program about, and I'd be interested in and the committee has probably talked about this quite a lot more than I have, but I and people like me who work in that setting will certainly want to have a sense of what the aspirations are and what's developing to make this program work in a facility that is stressed in its own ways. We do some things quite well, but and by the way, I enjoy my work there.
Thank you for your work there. So just because of all the different roles that you play, I think this is very helpful. Does the committee want to hear more, or do you want to, I would like to have you here when we're talking about the prison in general and,
Right.
But that's not this. But it is helpful to know and to just clarify that it is under stress, that the facility is, already in a challenging place. It isn't as if there's a nice big space that's vacant, for example.
Right. There are, I might comment there are, as was briefly mentioned, 3 places within the facility where probably people would be housed to fell into that category. The so-called Bravo unit is a living unit for people with mental health needs. Alpha is a more restricted, isolated living unit for people with more acute mental health needs. And some of the folks who fall into this category end up staying in the infirmary because they need closely supervised nursing care. And the infirmary has only 9 beds in it, and it has to serve lots of purposes. I spend quite a bit of time in that.
Okay. So I think this is good. This is helpful. And I know where to find you.
Yeah.
Yeah.
Thank you for inviting me to be part of today's
Yeah.
discussion.
Thank you for being here. All right. So I would like to continue this conversation at another time. I still would like an estimate of the number of folks the facility would need to be able to be there and get services. And I suspect there was some sort of square footage number when you were looking at the forensic facility before.
I sent you some information.
Oh, but good. Okay, thank you. And just the cost of the restoration services, cost of clinical director, and if DOC is the right agency to ask, or the right department to ask, we'll definitely get DOC in. So those are some of the questions that I have. And then I still feel like we haven't had a good, complete answer on where are they now, because I think some folks are in custody in hospitals. So I'd like to just know more about that.
So if they're in the hospital, they wouldn't qualify for this, but this specifically is not for folks that are in the hospital. That's the idea, is that it's for everyone who's not in the hospital.
Yeah, there's some specific people that I know, or I know of, so I don't want to ask that on camera, so
We can provide that
Okay.
anyway.
I do have one question, just to actually to clarify, and I think I know the answer to this, but this does not replace the current system. The current system stays as it is.
Yes.
And if someone fits into the current system, they go into that current system.
Absolutely. Yep. Yeah, the idea is not in any way to replace that. If someone needs to be in the hospital, they should absolutely be in the hospital.
right, and that was my understanding, is my understanding. Okay. Well, I think this is good for today. Everyone, are we good? Ready to adjourn? Okay, we are adjourned. And just